And welcome to South Texas Now, Part 2 with Diana Elizondo Zimmerman. And that's the Zimmerman Law Firm, and that's right there in Clayburgh County, but also around South Texas. With me today, I have Diana Elizondo Zimmerman once again, my colleague. She is an attorney extraordinaire and does family law, juvenile justice, wills, trust, estates, and guardianships. We're going to be focusing in on the wills, trust, estates, and guardianships. So everybody, please, on this part 2, just to remind you, part 1 covered the juvenile system, and we learned a lot about Diane when we, because a lot of the time we want to hear about the story about a lawyer and why they became a lawyer. So welcome back, Diane.
Thank you for having me back.
Yeah, part 2 of this segment. Thank you for sticking around. I think wills, trust, estates, and the guardianships, there is so much people don't know about this. So just the mic is yours, just to preach it. What are the important things to know?
I think everybody deserves to have a will or needs a will, regardless of what type of wealth that you may have accumulated throughout your life. Anything that has a title or a deed, you're going to have to deal with probate. If you have small children, you need to appoint guardians of either the person of who you want to raise your kids and who's going to handle the money for them. So a lot of people, I've come across are like, well, I don't own anything. I don't need anything. Why should I have a will? Well, everybody does own a car or a boat or, anything that has a title to it. It needs to be transferred, after death through a probate vehicle. So there's different means of getting probates done. There's, muniments of title, small affidavit heirships. So people kind of get scared with the word probate, but it's a very simple way of transferring personal assets over to different individuals. But most importantly, I think that everybody should have their powers of attorney, because those are what keep us out of the very expensive guardianships that many of us need, because with today's medical science, we're living longer.
Very much so.
So I think everybody needs the medical power of attorney to allow somebody to make medical decisions for them when they're in, an incapacitated moment. And not that they're always going to be incapacitated, but for that time period, like if you're in surgery, doctor comes out and needs to make a decision, there should be somebody appointed instead of the whole family fighting over whether or not they want a blood transfusion done. There's one individual that you can appoint to make, that decision for you. Then there would be the statutory durable, which helps you with your finances. And that can be done and executed whether it starts immediately the day that you sign it or upon your capacity. But that allows an individual to talk to the IRS, to Medicaid, Social Security, dealing with banks, anything that has to do with money. That individual can make those decisions for you without you having to be present. A lot of times we take care of our elderly parents, an elderly, neighbor, a relative, and it's hard to get them in and out of the car with a wheelchair, or they're just not feeling very well. So somebody that can go to the bank and, take care of their businesses, pay for their bills, dealing with Social Security, with Medicaid, Medicare, those are, those are very important daily issues that we deal with. So the durable power of attorney to me is also very important. The other documents that you would include would be a HIPAA. The release of HIPAA is allowing an individual to call the doctor to see what was in mom's test. Why is mom having to take this test? Why is mom's medication being up? Because sometimes, the older you get, you don't always pay attention. You're not listening to what the doctors are telling you, and you come home and then the kids ask 120 questions and you don't always remember everything that the doctor said. So the release of the HIPAA information allows somebody to call the doctor and to allow them to release the medical information that they have issues or questions with. And though the HIPAA also survives 5 years after you pass away. So if something does happen medically and you want to have it investigated, you still have that option of pulling those records for that individual that has passed away. And then you would have the directive. A lot of people confuse the directive with a DNR, but the directive to physician allows...
Do not resuscitate.
Yes, the do not resuscitate is a completely different document than the directive to physician. This allows you as an individual to say whether I have a terminable condition or an irreversible condition. In my last hours, just please let me go peacefully and no, medical heroics to be done to me. So it takes that, it gives the sick person the power to say, like, no more, I've had enough, and to just let me die with dignity. And it takes the pressure off of the family of when to stop treatment and when to start giving them comfort, towards the end of life.
It's a lot going on here, and let's break it down. First of all, the will. So many people, I'm not holding you to an estimate, but is it fair to say more than half of people, or about half, don't have a will when they pass away?
I would say it's probably more than half. Because
more than half?
We get a lot of calls to the office with that. My parent has died, and oh yes, my mom died also, and then my grandmother passed away, and we have a house, and they're calling us for taxes, and nobody that has passed has left a will. So now we're having to go back and do affidavit of heirships to determine who all the heirs are of the individuals to get to, to take care of a property or a lot that has been abandoned basically, and the state and the county is ready to move in to repossess the house over taxes that are due on the lot, and sometimes it's $10,000-$15,000.
Oh my gosh!
But nobody's left a will to leave that to an individual. So now you're dealing with 20-30 cousins that you have to round up to get names to get everybody lined up. So we get a lot of calls that several people have passed away, and now we need to go back and clean up the deed and get the correct people's names on it so that they could sell it or get out of a tax lawsuit by the county. Had
they made like a ladybird deed or something for a house, or made their will, how much money do you think that saves on average instead of going through the whole probate process and all the other things that go along with that? $2,000
to $3,000 easy. Like a deed, $250, $300 for a ladybird deed. Just a life estate deed, $200-$300 versus having to do an affidavit of heirship and the application. If you have to go through the court systems to get everything ironed out, you're looking at spending anywhere between $25,000 to $8,000 if you have a mess and you have properties that need to be taken care of and moved out of deceased people's names into the living heirs. And not everybody gets along. So eventually there are lots of petty fights that happen over property. It's inevitably, it always comes up.
And when we talk about trusts, a lot of people hear about trusts and things, but what are they set up for?
Trusts are set up to help protect against taxes, and it's helped to promote generational wealth. So if you, let's say, if me and my spouse had trust, I would be his beneficiary on his life estate, the house, whatever property that we own. I don't immediately get that tax burden for inheriting his portion of it. It gets protected by the trust.
Oh, wow.
So I don't have to pay taxes upon what I've inherited from my husband. Then whatever portion that I leave behind then goes to my children and stays in trust for them, so they're not inheriting, not that I would have a bulk of money to leave to my kids. But if, let's say, we left them $1 million at 18, our children aren't going to be receiving $1 million. They're going to, with a trust, be able to sprinkle that over the years so that they're looked after until 30, 35. When they're older, they can make more mature decisions. It protects them against bad marriages, debt. So having trust is a vehicle of being able to protect your assets and not being taxed immediately upon a person's death. Or you could also use trust for, in case you have somebody like a child that's incapacitated and they can't own money because then they lose their government benefits. So you would want to set up a special needs trust so that there are funds there for them, but that they're not also losing the benefits that the state gives them in order to maintain their life.
Like my good friend, the broadcaster, Carlos Lopez, with stations all over Texas, he has 3 special needs children. He and his beautiful wife, Adriana, would benefit totally from that sort of special needs trust.
Yes,
right.
Because it would protect the kids from actually having ownership of property. But it's there for medical needs, for any of the necessities that they need, but they don't own the funds, so that their government assistance is not stripped away from them, because whatever a parent can save and build up for their child would not be enough money to help an individual who has special needs, with the medical bills, the specialties that they have to go to,
right,
the care, the driving. You would waste all of this resources that you have.
Hundreds of thousands of dollars.
So yes, everybody with kids that have special needs to set up a trust to help them.
Well, this show's blown by. We've got less than a couple of minutes left, but I wanted to touch on guardianships. You don't have to be an attorney to be a guardian, right? What is a guardian? A guardian
is an individual that is sworn in by the court to take care of somebody who can no longer take care of themselves.
They don't have to be blood.
No, and it's very sad to say that if you have a child with special needs, the state of Texas requires that you become a guardian of your child that you've raised all of their life.
Wow.
So you have to then take the guardianship class, post a bond, and then yearly make reports on them. So guardianships are very detailed and very expensive, and sadly they're needed, for lots of different reasons.
Well, you've inspired me to do that, because we're getting a wave of the baby boomers born as late as 1964 are just about to retire. And Generation Xers, those of us that were born in the late 60s, early 70s, we're going to be retiring in a decade. And so there's going to be a lot of work in this area. What's the magic number to call at the Zimmerman Law Firm for these cases?
We need 361-516-0088, and we can help you with all your guardianship questions that you have.
516-0088, area code 361. And if they want to find you online?
It's ZimmermanLawFirm.com.
All right, we'll be posting that up. Diane, I'm so sorry we ran out of time, but this had to be done, this second show. We've covered the lifespan in law practice you're watching Diane Elizondo Zimmerman. She's been on the government side. She's got the experience there. She's been on the private practice side, and you've heard it, 361-516-0088. Call that number, 361-516-0088. We're out of time. Thank you, and God bless.